Good evening to the aspirants of the Andhra Pradesh plus Telangana State Junior Civil Judges 2023 screening test, which will be going to be held respectively in Andhra Pradesh. It is 24th April and Telangana 23rd April 2023. Yes, welcome to the aspirants of the JCJ 2023 and a multiple choice question. I made it very much clear today that because of the Ramadan month started over there, hence the timings are changed. So India time is 8:30 to 40 minutes, 45 minutes, 50 minutes, whatever it may be there. Yes, that is the thing which I want to make it out. And without wasting the time, let me come to the point of the shooting of today's class. Number one, negotiable instrument means dash either order or to the bearer. Number one, a promissory note. 2, bill of exchange. 3, traveler check. 4, check payable. Check payable by the order or to the bearer. So options: A, 1 plus 2 plus 3, B, 1 plus 2 plus 4, C, 2 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
Answer is B, 1 plus 2 plus 4.
Why?
Negotiable is అంటే ప్రామిసర్ నోట్ ఉంటుంది, బిల్ ఆఫ్ ఎక్స్చేంజ్ ఉంటుంది, చెక్ పేయబుల్ ఉంటుంది.
Why not the traveler check? Earlier it would be there, but now it is no more over there because we can draw the amount wherever you like in the Visa card, MasterCard. Otherwise, people used to take the traveler checks, buy it, and they will encash it there in the other banks. But now it is no more there, traveler check. So now the second question. The Negotiable Instrument Act 1881, Act number dash of 1881. What is the Act number? A, 24, B, 25, C, 26, D, 27.
C, 26.
Appreciate it is a 26 is the right answer. Now, third question. Negotiable Instrument Act 1881, Act number dash of 1881, how it could be returned? A, uppercase Roman number 26, and B, cardinal Arabic numbers. C, it is written in the words 26. D, lowercase Roman numbers. Among the ABCD which I have given, which is the right option?
B, sir.
Say
2 and 6.
yes, 2, 6. What is that number?
Number.
It is the cardinal Arabic number.
Okay.
Yes, now the fourth question. Section 35 in the Negotiable Instrument Act 1881, and I made A, B, C, D. And in one, I made a mistake. And you want to find out where I made a mistake. So now, let us see the Section 35 of the Negotiable Instrument Act 1881. A, in the absence of the contract to the contrary, whoever endorses and transports a negotiable instrument before maturity without in such an endorsement. B, expressly excluding or making conditional his own liability is bound thereby to every subsequent holders in case of dishonor by the drawee, acceptor or maker. C, to compensate such a holder for any loss or damage caused to him by such dishonor, provided due notice of dishonor has been given to or received by such endorser or hereinafter provided. D, every endorser after dishonor is liable upon the instrument payable on demand. So among the all A, B, C, D, I will drag to here. Which one is the wrong statement?
Yes, sir.
Okay, if I say A, why it is wrong? You have to give the answer. Because when I draw it, you saw the A here, but anyway, it doesn't matter. You tell me what is the Why it is wrong? What is the reason? Say, Pasan.
And okay, whoever endorse, not a endorse, and transport delivery a negotiable.
No, what? Where the host changed the word. You tell me. Which word I changed, and what should be the right word?
Okay, transport.
Transports is. It is not transports. It delivers.
Yeah.
It delivers, not transports.
Hmm.
Okay, now fifth question. Match the following. 141 presumption in favor of the holder. 2. 140 defense which may not be allowed in any prosecution under section 138. And 3. 139 offenses by companies. 4. 138 dishonor of checks for insufficiency etc. of funds in the account. And options: A 1 plus 2, B 1 plus 3, C 1 plus 4, D 2 plus 4. Mismatch, I told you. I repeat, mismatch. You're taking so much time. Perhaps you are referring the
Match.
smartphone.
Okay.
Here I have given
One,
mismatch is
one,
B,
three,
1
one
plus
plus
3.
three plus
Here I
three, one
mismatched
plus
is
three.
141 offenses by companies, I said. But here I wrote 141 presumption in favor of the
Presumption of
holder.
favor holder.
Then here I changed it 4. 3. What is say offenses by companies 139.
Company
But actually it is a 139 presumption in favor of the holders.
in favor of holder.
Yes, that was the thing which I yes. Sixth question, read.
Section 87, discharge from liability. The maker accepted or
Which is a section
endorsed.
87. Where is the section 87? Sixth question.
Okay, 82. Okay. Now it's clear, sir. Present not clear. Section 82 of discharge from liability. The maker, acceptor, or endorser, respectively of a negotiable instrument, is a discharge from liability thereon. 1. By annulment, by cancellation, by release, by payment. A 1 plus 2 plus 3, B 2 plus 3 plus 4, 1 plus C 1 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
One option I created. 3 options are correct. In among 1, 2, 3, 4. Discharge by liability is true by cancellation. By release, true. By payment, true. I
By annulment.
inserted by annulment.
And
So the right answer is
1, 2 plus 3 plus 4.
2
B.
plus 3 plus 4 is the right answer. Because remove the 1. Now seventh
Yeah.
question. Yes, let me read it. Seventh question.
Sir.
Because which state is correct? Which which statement is correct statement among the following 4 option? Which
Okay.
statement is correct statement among the following options? So now let us see. Yes. Number 1. I mean here I did not number it. Okay. A, B, C, D. Okay. Now let us resume it. Notwithstanding anything contained in the Code of the Criminal Procedure 1973, 2 of 1974, or any judgment, decree, order, or direction of any court, all cases transferred to the court having jurisdiction and subsection 2 of the section 142. And B, here I will make it a B so that you could not confused. B. Notwithstanding anything contained in the Code of the Criminal Procedure 1973 within parenthesis 2 of the 1974 or any decree or judgment order or the direction of any court, all cases transferred to the court having jurisdiction under the subsection 2 of the section 142. And now the C. Notwithstanding anything contained in the Code of the Criminal Procedure 1973 and 2 of the 1974 or any judgment, order, direction, decree or of any court, all cases transferred to the court having jurisdiction under subsection 2 of the section 142. Now the D option. Notwithstanding anything contained in the Code of the Criminal Procedure 1973 within parenthesis 2 of the 1974 or any order, judgment, decree or direction of any court, all cases transferred to the court having jurisdiction under subsection 2 of the section 142. So I read total 4 options, statements A, B, C, D. Now you tell me which statement or option is the correct option. Either A, B, C or D.
C, sir.
WRONG. You see the word by word, sequence by sequence. If you happen to see the sequence, I changed the sequence. Now check it. Which is the right sequence?
Okay.
I have given the hint also. Yes?
D, sir.
WRONG.
Judgment, decree, order.
See, if
Yes, sir.
you studied this thing, which come first, which come later, which come last?
Okay. B, sir. First preliminary decree, next judgment or order.
A is the right answer. Any judgment, decree, order, or direction of any court. All the cases transferred to the court having jurisdiction under subsection 2 of the section 142. So A is the right answer. Now, 8th question. The Supreme Court in dash, it is delivered by T.H. Thakur, Vikramjit Sen, C. Nagappan, J.J. held that the jurisdiction of the court in matters where the check is returned unpaid was restricted to the location where the check was dishonored, that is, the check was returned unpaid by the bank on which it was drawn. A. P. Mohan Raj versus Shah Brothers Ispat Private Limited. B. H.S. Vikram Dev Malhotra versus Rajesh Lamba. C. Dashrath Roop Singh Rathod versus State of Maharashtra. D. Karthi P. Chidambaram versus Superintendent of Police.
D, sir. C. Dasarath Roop Singh Rathod versus State of Maharashtra.
I appreciate. It is the Dashrath Roop Singh Rathod versus State of Maharashtra is the right word. Because in this case law, they referred where is the jurisdiction to file a case, especially in the check bounces cases. So in general practice is there where the check is made for the payment and the deficiency of the account is there in particular place. That place, bouncing of the check and which area it comes, the bank and the judge jurisdiction, that police station having a right to file a case. So that is the case law. Ninth question. The checks presented by the respondent to the appellant were returned by the bank with an endorsement not arranged funds for. At the request of the respondent, the appellant did not present the said check since the respondent agreed to settle the dispute. However, the respondent failed to settle the dispute subsequently. In these circumstances, on 8 January 1997, the appellant sent a notice to the respondent under the section 138 Class B of the Negotiable Instrument Act of 1881 and hereinafter referred as an act. The respondent duly received the said notice. Subsequent there, those checks were again presented before the bank on 21st January 1997 by the appellant. On the presentation, the said checks were dishonored for want of sufficient funds second time also. These are the facts of the case law. Now you tell me which case law facts these are. A. Measures Lathers versus S. Palaniyappan and others. And B. Kishan Rao versus Shankar Gowda. C. Measures Meters and Instruments Private Limited versus Kanchana Mehta. D. Srimati Asha Bhadwa versus Ram Gopal. Shoot.
Now answer is C, sir.
Yes, C is the right answer. Measures Meters and Instrument Private Limited versus Kanchan Mehta. This is the facts of the case law. And now the next case law. 10th question. A complaint was filed under Section 138 of the Negotiable Instrument Act by the respondent against the petitioner and her son. The complaint proceeded after an inquiry. Cognizance has been taken against the present petitioner. It is an admitted position that the check was issued by the son of the present petitioner. It is also an admitted position that the petitioner was not the original partner in the firm but came into the picture only when her husband expired and she entered the firm. Which is the facts of the case law among the four which has given below? Yes. Number 1, Ved Veer Singh Sejwar, son of Sri Ram Sejwar, and another is SMT Asha Badwa versus Ram Gopal. Then another is Ram Babu Sharma, son of Ramakrishna Sharma versus the state of Rajasthan through the Principal Secretary, Panchayat Raj Department. And D. Manu Ram versus state of Rajasthan. Among these four cases, of course, here I did not made who is verses. I wrote only with Veer Singh Sejwar, son of Sri Ram Sejwar. Verses should be there. Okay, doesn't matter. One is eliminated. Then out of 3, which one is the right answer? Participants, are you checking the smartphone?
B,
The right
sir.
answer, yes. Say,
Srimati Asha Badwa versus Ram Gopal.
did you check in the smartphone or did you type it in the laptop?
Smartphone, sir.
Then why do you check it like that and make the answer? And you will be the loser and you will become a parasite. In the exam, smartphone is not allowed. So don't do like that. Use your own intellectual idea and shoot it. If not, you will become a parasite. You cannot use your brain. You cannot brainstorm your brain. So please try to avoid it. Because I got the doubts. You are giving the right answer after some time. Then I got the doubt that you are checking the smartphone and giving the answer to me. If you know the real answer and at the end of the D, you may shoot it. That means you know the answer, somewhere you read it and you used your brain. So that is the method that you have to adapt it. Otherwise, you will become a parasite. In the examination, I will show you what they said in the timetable which I have given to you, TT. They specifically mentioned section 138 to section 142 capital A. See,
Only chapter 17.
Here, section 138 to 148
148.
capital A. If you happen to see these sections, how many are there? Say 11 sections, including
10
or 12
A.
sections, 148A. Do you think that they do ask the question in this only? Answer is no. But they are not supposed to give in that way. Because questions can be asked from anywhere in the negotiable instrument. But I don't know why they have given in that way. If I read in the another, I did not find the sections. They say Negotiable Instrument Act. I don't know whether in Andhra Pradesh what is given. Do they given only Negotiable Instrument Act, or it is there or it is not there?
There, sir. AP also.
It is there or it is not there? Specific sections. I asked the question in the Andhra Pradesh RTS, because this is TS, I know it. They specifically mention section 138 to 148 capital A. Whether the
It is
same
not
thing,
mentioned in the AP.
that's why I got the doubt.
Those sections,
All
138
the
to
sections can
148
be
is not.
referred.
Sir,
They are only not
how
the
much?
specific sections. All the sections
Not
should be referred.
all the sections, sir.
Yes, that's why I'm saying all the sections should be referred. Means you
Okay.
have to check the all the thing. Now the supplementary question. How many sections are there in the Negotiable Instrument Act? Shoot, don't check in the smartphone or laptop.
I don't, but sir,
See this.
I have only, sir, I have only smartphone. మీ క్లాస్ ఒక్కటి నేను స్మార్ట్ ఫోన్ లో చూస్తున్నా నాకు ఏ ల్యాప్టాప్స్ లో ఏ అనదర్ మొబైల్స్ నాట్ హ్యావ్ ప్రెసెంట్ హ్యావ్
Okay. Now, how many sections are there?
147 sections.
Yes. Why do you say in Telugu language? Why don't you speak in English? Sir, I am not that much expert in English. If you speak
Yes,
in the
sir.
beginning,
I'm not expert.
if you'll make such a mental attitude, if you frame such a thing in your mind, in your life you never speak in English.
Okay,
So
okay.
don't frame that English is only for the foreigners or the Britishers or the Americans. Answer is wrong. Because they use the mother tongue, that is their English. Otherwise, if our father, mother use the mother tongue English and our mother tongue also be in English. Is it clear? So here schedule 1, here schedule enactment represented by the repealing Amendment Act of 1897, 12. So a schedule is repealed here. And what is another, any other point is repealed here? I think one day we checked it in, I don't know whether it is here, whether section 2 is repealed here. No, there is a different act, I believe.
Indian Evidence Act లో only section 2 and schedule is repealed.
Here also, Negotiable
Same
Instrument
thing.
Act, 2 is repealed.
2 is repealed.
And
Okay.
check it is, any other thing is repealed? Answer, no repealed. No repealed. No repealed. No
No, sir.
repealed. No repealed. No repealed. And here also no repealed. No repealed. Here also no repealed. Here also no repeal. That means the same like Indian Evidence Act, Negotiable Instrument Act also, the same
Sir.
thing happened.
Sir,
Yes.
present 148 sections is there's a Negotiable Instrument Act, not 147.
I don't know from where I downloaded it. Let me check it. Because when I say latest act, I downloaded it. Now let me check it whether how many sections
One
how many sections are there in the Negotiable Instrument
instrument
Act
act.
latest amendments?
Amendments అంటే మళ్ళీ వేరే వస్తుంది సార్.
Let me
Only
check it.
latest అంటే అయిపోతుంది.
Yeah, here it is given. The act has been
148.
promulgated in the 1881 originally, but was amended by the Parliament of India from time to time. This statute is aimed to define and amend the prevailing law relating to the promissory notes, bill of exchange and checks. The sequence is first promissory notes, second bills of exchange, third is checks. This Bear Act has 17 chapters and 148
And
sections.
148 sections.
So, how many chapters are there? Supplementary question,
17
chapters. How many sections are there? 148 sections.
148 sections.
How many sections are repealed? Or how
Only
many
section
things
2.
are repealed?
2 and schedule. Only
2 and
section 2
schedule is repealed. That is the
repealed, yeah.
answer. And what is the latest amendment?
Only promissory note, bills of exchange and check.
Latest amendment.
Latest amendment only check, sir.
138 latest amendment. The amendment bill insert the new 143 capital A in the Negotiable Instrument Act of 1881 to provide the court right to offense under the 138 may order the drawer of the check to pay the interim compensation to the complainant in a summary trial or a summon case where the drawer pleads not guilty to the accusation made in. So 138 section is the latest amendment where he has to give the interim relief. So that was the thing. But what is the latest amendment? 2000? See here, latest amendment to my knowledge, 2018. Is it clear?
Yes, sir. Yes, sir. 2018 lo only check is amendment, sir.
Okay. So necessary amendments have come over there, and the supplementary questions may ask in this way. And in which chapter there is only one section would be there in the negotiable instrument? Is it such a thing is there? In which chapter only one section is there in the negotiable instrument? Let me check it because I when I was referring it, I found only one section. I don't know where I think the last section.
Indian Evidence Act lo only one section is there, sir. In 11th chapter.
In the 15th chapter, there are two sections are there.
2 sections.
And in
Yes.
the 11th chapter, in the 10th chapter, there are 3 sections. In the 11th chapter,
Okay. 12th chapter only one section, sir.
yeah, 12th chapter,
12th chapter.
rule as to compensation. So supplementary question, in which chapter there is only one section? Answer is chapter 12. What is that section?
12.
Supplementary section. Question. It is
Rule.
117. Rules as to compensation. So
Okay.
that is the way that you have to make the. What are the presumptions are there in the legal instruments? Number 1, A, consideration, B, date, C, date of acceptance, then D, when the date,
As to time.
where I suppose instead of time I write, see here instead of time I write as to day of transfer. Whether day of transfer is applicable. Whether the day of transfer is applicable.
Day of transfer is.
Answer is no. Date of transfer is applicable.
Okay.
Time of acceptance is applicable. But day of transfer is not applicable.
Okay.
What about the endorsement? Yes, it must. What about the stamp? Answer, yes, it must.
Stamp.
Instead of saying stamp, can I say seal?
See, only sign, not the seal.
Not stamp?
Is not a valid.
So this is the supplementary questions. So how many way the check will be crossed? See, in generally, how do you cross the check? At the right hand side corner, left hand side corner,
Parallel lines.
or the lower bottom of the left hand side, or the lower bottom of the right hand side? Answer is in the left hand upper check will be crossed. I will show you the images to you. See, did you see here? He crossed it. Not negotiable.
Okay.
Did you see it? Here, cursor.
Yes.
But generally the people will not do like that. People will do like this here. In the edge.
Yes, yes, sir.
In the edge they can make it out. Not wherever that like it. What does the cross check look like? A cross check is a check that is crossed with two parallel lines, either across the whole check or through the top left hand corner of the check. What is the best method? What is the best method? Say the top left hand corner of the check. Say. No, I could not hear your voice. It is the top left hand corner of the check. A double line. No,
Yes, sir.
parallel. I said
Parallel.
double line parallel. That is the mode of crossing the check. What will happen if you cross the check? What will happen if you cross the check? You cannot take the money on the spot. You have to deposit in your bank and whose name is written on the check. Am I right?
Yes.
If you don't cross it,
Anybody can transfer the money.
either you can back sign it to any other
Only-
person or any other person can also draw it. But your endorsement should be there. If you say the bearer, endorsement is not needed. Am I right? But that fellow will ask, who? Bank. Sir, is it given to you? Answer, you say yes. Okay. What is your name? So and so. Do you have the account here? Can you sign on it? Suppose if you have the account there and he will ask you to sign and he will check with your signature and what they do hide. And he will ask you, sir, it is not given to you But of course, he will not make any argument because it's a bearer check. It's a bearer check, he will not make an argument and he will give it. But sometimes when he got the doubt, when the amount is big, and he will say, sir, he will just say, can you take another signature here because there is some correction is there. And he will say that instead of saying, we don't give you, see there is a small correction is here, can you take another signature here? If really it is given to him, he will take the another signature. Or he was given to somebody else also, he can take the another signature. And that is the counter signature would be there, then they will give the money. But generally, no one give the bearer check, but only you will give the cross check. In case the bearer check will be given to those who are close relatives to you, and at the time the bearer check would be given. Am I right? So, what is a crossed check called? The crossed check are also used to redeem deposit with the bank. The cross check is usually promissory note with a bank endorsement and is often referred to as a banker's draft or banker's check. Even the banker's checks also there. And the banker's check and banker's drafts also there. And it will be given you, yes, it is also a valid transaction where we can make the money with the banker's check. What is the difference between the cross check and normal check? Cross check lines ensure that irrespective of the whose presents the check, the payment will only be made to the individual whose name is written on the check. Suppose the name is written on the check, and for that man only it will be money will be given when it is crossed. But when first it will be deposited in his own account and later on it will be given to you. What is the major section where the cases will be filed under the negotiable instrument? At any time Cisco Webex will stop. I repeat the question. Which section? The number of the cases will file in the Negotiable Instrument Act.
Section 138.
It is a section 138 and which is said to be the bouncing of the check or no sufficient deposit will be available in the bank and it is a dishonor of the check.
Insufficient funds.
Yes, insufficient funds, either dishonor of the check or a check bounce. It is a criminal offense. Of course, the intention of the person will be taken into consideration, but sometimes they fabricate also, and to harass the people, they will also make it out the case. At that instance, we can make a criminal case against. A private complaint will be lodged because the signature which were there on the check is not mine. So a private complaint can be lodged and the police make an investigation on it. And if he finds that he made a fabricated or a false or a counterfeit or duped signature would be there.
अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नाम तव आह्वान प्रचारित सुनि तव उदार